This is Law Bites, a podcast with Michael Geist.
Did you know the Competition Bureau of Canada is taking action to promote right to repair? That's because this action will provide great benefits to Canadian consumers, businesses, and the economy. We advocate for rules and regulations that will make competition work for you. You've probably heard of copyright protection regulations, and they have an important role to play, but they shouldn't create unnecessary barriers to getting things repaired. So what is the Competition Bureau doing to help? Our job is to advocate to regulators and policymakers. We make sure regulations don't create unnecessary barriers to competition, including access to parts, tools, and information.
The right to repair would seem like a political no-brainer. Policy designed to extend the life of devices and equipment and the ability to innovate for the benefit of consumers and the environment. Yet somehow, copyright law has emerged as a barrier on that right, limiting access to repair guides and restricting the ability for everyone from farmers to video gamers to tinker with their systems. The government has pledged to address the issue, and Bill C-244, a private member's bill that's making its way through the House of Commons, would appear to be the way it plans to live up to that promise. Two of the most outspoken experts on this issue have been Alissa Centivany, an assistant professor in the Faculty of Information and Media Studies at Western University and the principal investigator of a SSHRC-funded research project on the right to repair, and Anthony Rosborough, who's completing his doctoral thesis at the European University Institute in Florence and is set to take up a joint appointment in law and computer science at Dalhousie University later this year. They join me on the podcast to talk about why the time has come for government action, their experience before a House of Commons committee on the bill, and to unpack some of the confusion that's arising from late-breaking amendments. Alissa and Anthony, welcome to the podcast.
Hi, thanks for having us.
Okay, thank you so much both for joining me. You've really been two of the people who have been preeminent in Canada, I think, over the last while on this issue as we talk about the right to repair and where things stand in Canada. I certainly want to get to the substance of the issue and some of the recent developments that we've seen take place in Canada, particularly in the House of Commons. But before we do that, I'm curious what drew both of you to this issue. Why don't we start with Alissa? What prompted you to get into the issue of right to repair?
Yeah, I've been working on technology, policy, law, and ethics issues for a long time now, looking in particular at the ways in which technology, law, and social practices co-evolve and where tensions oftentimes will arise. And so in terms of my research interests, the right to repair sort of lands in the sweet spot. But these issues also resonate with me personally, I think, as they do with many others. So breakdown is normal and ultimately inevitable. And so too, I think, is this human impulse to repair, to fix things, whether that's a technological object or our relationship or our bodies. So without the ability to fix things, we end up feeling like broken people living in a broken world. And that's not a place where any of us want to be. And so aside from my interest as a researcher, I'm interested in how right to repair sort of speaks to or reflects some of our shared experiences as humans across economic, geographic, political, and social differences.
Okay, interesting. Anthony, how about you?
Yeah, I think, if I go back far enough, my interests kind of come from my family upbringing on the East Coast. My grandfather was a yacht designer, and my family runs a boat building business. And I spent most of my childhood building and fixing things and learning from my uncle, who just has this incredible ability to diagnose and fix just about anything. And so I kind of developed into a love of mechanical work and for old motorcycles. And I find it really rewarding and empowering to rebuild and revitalize old things. And I guess I've kind of ascribed to that view from Robert Pirsig's classic Zen and the Art of Motorcycle Maintenance that, in adopting this belief that repair can teach us a lot of important life skills and can make us better people. But I think my interest in the right to repair as a legal movement started all the way back in 2011 when protections for digital locks in Canada were being debated in Parliament. I was enrolled in an undergraduate course at Dalhousie University at the time, focused on the philosophy of computer science. And I just became fascinated with the social, moral, and ethical implications of locking down computers. And so actually I was drawing from a lot of your work at the time, Michael, and I wrote a short paper about how the law could maybe eventually lead to a reality where we're unable to fix our home appliances. And so it's just sort of been on my mind ever since through the law school days and into my academic work.
Okay, thanks. Those are both really interesting answers. And certainly I remember those times well, and issues around right to repair, or access to our cell phones, and the kind of different things, especially around that, was really top of mind for a lot of people, more than a decade ago when we were engaged in copyright reform. So I covered this issue in a prior podcast. I think it was a couple of years ago now. But for those new to the issue, can you explain what it involves? I think most people would think, frankly, they're entitled to repair or tinker with the products that they purchase, and I'll be a bit surprised to hear that there may be an impediment. How has this issue sort of come to the fore?
Mm-hmm. Well, there's a number of impediments, actually. So, repair right now in Canada and elsewhere is being impeded by design choices, by business strategies, by restraints on access to material and information resources, laws, which I think we'll talk more about today, and various social factors. And right now, we have few policies that make repairability and associated concerns like durability and interoperability and so forth imperative. So we need repair imperatives. Most manufacturers, I think, have sort of increased profits at all costs kind of business model. And so we need tools to temper that for the good of the economy, for the environment, and for our communities.
Okay. Anthony, did you want to add something?
Yeah, I mean, I think at a fundamental level, I think the answer you'll get when you ask a lot of folks about what is the right to repair all about, and the common sort of list of things is about access to parts, tools, and information, including software that are necessary to repair the things we own. And so I think while it's true in theory that we are entitled to repair or tinker with the things that we own, the reality is really different, right? And Alissa mentioned some of the ways manufacturers can restrict access to parts, tools, and repair can also be prevented through design and requiring special tools or parts or mechanisms that make it really difficult for someone to fix something. But I think on the whole, right, the repair can kind of vary along different lines, right? Like whether it's construed as a positive or a negative right, whether we're trying to impose obligations on manufacturers or merely just enacting negative rights. So it's saying, manufacturers shouldn't be allowed to restrict folks from independent repair, or whether we should, force them to take certain action. And also there's different characterizations of the right to repair, whether it's a purely IP issue, whether it's a consumer law issue, whether it's a competition law issue. Of course, the reality is that it's all of those things, but we see different flavors of the right to repair based on the different priorities of governments.
Okay. I mean, so both of you really succeed and highlight sort of this really broad range of considerations that come into this issue. I'm going to narrow things down primarily to the copyright related issue, which, I must admit for most people, they would have no clue. Why on earth is copyright a factor when you've highlighted all these other things? It's one of those things. It just feels like it doesn't belong. So what is the link? How is it that suddenly the Copyright Act or copyright reform has implications for these repair right issues?
I mean, if it doesn't sound like it should be a copyright issue, I think that's because it probably shouldn't be. But copyright can touch on repair in at least two ways. The first is the ability to prevent the dissemination or sharing of published documentation that explains how to repair things. So this could be factory repair manuals or schematic diagrams that are included in other published works, or other types of information, parts lists that assist in repairing things. And so there's precedent for manufacturers using takedown requests for online providers that host repair information under the auspices of copyright, to make sure that can't be distributed. But the second sort of main way, and I think the subject of our conversation today, is copyright's embrace of computer software as a protected work, eventually led to this recognition of access control technological protection measures, sometimes called TPMs, sometimes called digital locks, depending on who you speak to. And so, these were originally intended to prevent unauthorized copying of digital content at the turn of the millennium. And they can be any technology that prevents access to copyright works, including software. And so in modern times, this usually comes down to encryption. So any device that's computerized, which uses encryption to prevent access or modification of that onboard software, be it your smartphone or your laptop. But it can also include things like proprietary connectors or cables or physical interfaces of devices that prevent someone from modifying software. So those are the two main ways that copyright kind of touches on repair.
Okay, but before we jump into specifically the kind of some of the reforms that we've seen in the House, one of the surprises I think for some people is that somehow the agricultural sector has become one of the leading proponents of dealing with some of these issues. When Anthony mentioned the copyright reform more than a decade ago, and it really was primarily about computer electronics and cell phones that people paid most attention to. But of late, the agriculture sector has really been, I think, at the forefront of highlighting some of the concerns. How do they come to this issue? I mean, as remote as it might be, copyright and repair, it feels even more remote that somehow the farming community, the agriculture sector, would have copyright concerns in this way.
Yeah, so what we're seeing is that an increasing sort of range of devices and equipment are being computerized, and that includes things like tractors, right? And so in terms of why the agriculture sector has played such a large and important role in the right to repair movement, I think fundamentally boils down to the fact that it's a really compelling story, right? Like, we have the situation where we have farmers who, work with the land and produce food that we all need to survive. And having their sort of practices of repair and maintenance, modification, things that they've always sort of done, being impeded in these really bizarre ways by a manufacturer who's sort of co-opting copyright law to do things that just offend, I think, common sense. And so it's a really compelling story. There's also, I think, been a lot of sort of obvious and well-documented overreach by manufacturers like John Deere, who have a concentration of power in the sector. And so there's we have a lot of evidence about some of these egregious practices that are taking place. Like I said, agriculture is a critical sector, and the consequences of impediments to repair can be extreme when we're talking about agriculture. So, during a planting or a harvesting season, time is of the essence. And so if there's a delay in a farmer being able to have their equipment working, that can be disastrous and cost a lot of money and result in crop loss. In addition, I think the last point that I'll make here before Anthony jumps in is that we've seen that farmers are really great at advocating for themselves. They're really sophisticated about their work, about their equipment, and they have, developed a really strong sort of collective grassroots organization around these issues and have been excellent spokespeople for the issue more broadly.
Okay, I think that does a nice job of pulling all of that together. So that effective advocacy and that compelling story has led to the Canadian government taking on this issue. And frankly, over the decades since some of the major reforms, the idea that this would sort of steadily move towards almost the very top of the list is an interesting phenomenon in of itself. Why don't we start with where is the Canadian government on this issue? Because I know that it has been now referenced, certainly in the most recent budget.
The Canadian government's been sort of debating and considering the right to repair in various forms for almost 25 years. And much of that early work was focused on the automotive industry, led principally by MP Brian Massey. And so as familiarity with the right to repair has grown, thanks to advocacy from folks like farmers, the clearest recognition of the right to repair in Canada came part of the Liberal Party of Canada's 2021 electoral platform. There, the Liberals promised to implement a right to repair, focused mostly on home appliances. And as part of that promise, they identified a few ways of actually implementing it and what it means. And the first was a tax credit for home appliance repairs. The second was measures to better inform Canadians about the environmental impacts of consumer products, they've said. So not necessarily repairability of products, but about the environmental impacts of products. And finally, the third was to amend the Copyright Act to ensure that the repair of digital devices is not restricted. And looking at how they've done on those three fronts over the last few years, so that the tax credit is apparently forthcoming in the 2024 budget. And Bill C-244, which is kind of the impetus for our chat today, seems to be the most concerted effort to deal with the copyright issue. But yeah, we've yet to see much issue or movement really on how consumers will be better informed about the repairability or environmental impact of devices. But overall, the government seems fairly committed to pushing the agenda forward on the right to repair. But I think, personally, I think a lot more leadership is needed in playing a kind of unifying role with the provinces and dealing with the consumer protection issues, and not just looking at it purely as a copyright issue and kind of an easy slam dunk win from a legislative political perspective, but actually dealing with repairability in its kind of more complex reality.
Okay. I mean, and that's a fair point. But as someone who focuses on copyright a lot, when you're hammer, everything looks like a nail. And when you focus a lot on copyright, everything looks like a copyright issue to be solved. So we've got this Bill C-244, which for those that pay attention to even the numbering with respect to bills, they'll note that's a pretty high number, which reflects the fact that it starts life as a private member's bill. Alissa, can you walk us through, who introduced the bill and what does it do? And what have we seen progress so far in the House of Commons?
Sure. So that was introduced by, and I apologize, I may mispronounce the name, but MP Meow. And this bill provides an exemption to the provision of the Canadian Copyright Act that deals with technological protection measures, and it would allow for the circumvention of TPMs for diagnosis, maintenance, and repair. And so in its initial sort of instantiation, this bill, I really liked this bill in particular because it was really sort of broadly worded. It wasn't industry specific, and it focused on the range of activities that we're really interested in promoting and protecting here. There's been a subsequent amendment which has narrowed and carved that out a little bit, which we can talk about.
It might be useful actually just to provide even a bit more background,
Sure.
on the anti-circumvention rules and why we need an exception for this in the first place.
Yeah, sure. So, I mean, we talked about TPMs and or digital locks, however, whichever label you'd like to use, as being, principally intended to prevent copying or unauthorized reproduction, infringement of copyright works. But with the kind of widespread proliferation of embedded computer systems, and what I mean by that is devices that are now basically specific purpose computers or smart devices. This means that copyright governance through software is now kind of spread throughout the world. It's now become ubiquitous that everything now kind of has a software component, and that software can determine how the entire device functions, whether it works with other devices, whether you're able to maintain, diagnose, or repair it as well. And so what we're seeing really is that TPMs are becoming a real impediment to repair. And one of the reasons that that agricultural equipment has become this big issue is on a technical level, the problem is really through onboard computers serve as a sort of point of authentication. So all of the parts of the device or the machine are serialized. They all have a serial number. And if any of them are replaced or modified, they have to be authenticated by the onboard computer for the entire device to work. And this model is classic in the automotive industry, but it's new to things like your telephone or your computer. It's a new kind of design model that sort of imbues a lot of stuff with copyright governance. So now, like, the technical functioning of physical devices is now the subject of copyright law. And so what this bill is trying to do is to deal with those downstream implications in the context of repair, maintenance, and diagnosis. So it's a targeted exemption to kind of allow those specific activities when we're dealing with devices that have embedded computer software.
Okay, so that's what it's designed to do. Now, both of you appeared before the committee that was studying the bill. I'd love to hear about that experience. What did you have to say, and what kind of response did you get from committee members? Alissa, why don't you get us started?
Sure. It was a really fantastic experience, actually. In part because I think there's widespread support for right to repair reforms. So it was nice to sort of participate in an important discussion where it seemed like everybody was kind of on the same team, which doesn't happen that often, right? So in terms of the sort of things that I wanted to emphasize in my statement, my comments to the standing committee, I really wanted to drive home the fact that the purpose of copyright is to benefit society by promoting the creation and sharing of creative and artistic works. It's not to enable manufacturers to protect their business model. And that's sort of essentially what manufacturers like John Deere are trying to use copyright to do. So, it's absurd that things like tractors, tanks, washing machines, wheelchairs can have, the consumer's ability to repair them be impeded simply by embedding a little bit of code into those devices. So I see this bill as carving out a necessary sort of common sense exemption to the Act's anti-circumvention provisions. I also spoke to some of the opposition arguments in my statement. And oftentimes the kinds of arguments we hear in opposition to this bill are things that deal with risks to the environment, to safety, and to security. And so what I wanted to make really clear to the committee was that those kinds of arguments are barking up the wrong tree, essentially. We have other laws on the books that could address those concerns, but copyright is not the law that we should be looking to protect those interests. In addition, I noted that the only way that this bill could impact things like emission safety and security would be that if the software that governs repair also governs emission safety and security. And so I don't think that these systems are being bundled together, but if they are, that's a sign that there's a design flaw that manufacturers need to remedy. In addition, I talked a lot about sort of consumer interests and consumer rights. I talked about how manufacturers' tendency here to position consumers and the third-party repair technicians that they might choose as threats in some way, as really anti-consumer. And I said, to the extent that there are, legitimate security risks posed by sophisticated hackers, those are risks that are sort of always going to be present in some respect, and they're always going to sort of be able to have tools and techniques at their disposal. And so we shouldn't sort of impede repair on that basis. The last point that I'll make before we hear about Anthony's comments is that a lot of opponents sort of suggest that enabling repair is somehow anti-innovation or would undermine innovation. And what I found through my research and through interviewing lots and lots of people all over Canada and the US and Europe and the global South is that the process of figuring out what's wrong with something and fixing it is hugely innovative, right? So our understanding and our evaluation of innovation, I think, in this country has gone awry. We overemphasize things like novelty, newness, and invention, and underemphasize, I think, the sort of skill and learning and adaptive situated problem solving that's required to be able to undertake repairs and fix things when they break. So this bill also, I think, is really pro-innovation, it's pro-consumer, and it's, I think, in line with the overall purposes of the Copyright Act.
Okay. That's a pretty great statement in 5 to 7 minutes, I got to tell you. I've struggled to manage to get that much in some of my opening statements. Anthony, what did you have to say to the committee?
Yeah, I mean, I guess my remarks were more focused to kind of within the four walls of copyright doctrine and theory. And I think intentionally knowing kind of how Alissa was going to approach it and wanting to make sure that it complemented what she was saying. But my focus was really on looking at TPMs that inhibit repair as a misuse of copyright. And that's, maybe rather than enacting targeted exceptions permitting repair or other activities, because we know there is another bill, sort of a parallel bill on the books for interoperability purposes. My recommendation was rather than take this approach at all, we should consider amending the Act to not extend protection to TPMs that prevent acts unrelated to copyright infringement. So, that there should be some nexus between infringement and circumvention in terms of its lawfulness. And so, I'm not sure that was, wholeheartedly adopted by the committee, but I mean, that was kind of the purpose, was to say, we could be here next year talking about some other kind of activity that's been restricted by TPMs that has a social and economic benefit that we need to protect. And so that we should kind of deal with this more on the front end. And now a witness for the Electronic Software Association raised concerns that the bill could be relied upon to allow infringement under the auspices of copyright. So the concern was that repair could be used as this excuse, right, to engage in all these infringing acts. And I think my entire point was really to refute this idea, and that what we're concerned about here is, in fact, manufacturers preventing activities like repair or other maintenance under the auspices of copyright. And so what we should be really worried about is not, characterizing infringing activities as repair, but manufacturers characterizing repair as somehow subject to copyright. And I also responded to some concerns raised by opponents of the bill, and this paralleled what Alissa was saying about, whether cybersecurity or public health and safety should be taken into consideration when we're talking about repair exceptions. And so, even if these concerns are well-founded, which I think is very questionable, it's really not the role of copyright to be regulating in these areas. We have a number of other tools at our disposal, and copyright law is kind of a special thing, right? It's a grant of property rights for very specific subject matter, and so we shouldn't use it as this kind of catch-all regulatory framework that can police a whole bunch of conduct that has nothing to do with expressive or creative works. And so that was the kind of cautionary message behind my submissions.
Okay. Well, I'm glad somebody said it, and it's important, I think, to make that point before committee. Now, Alissa, you mentioned that you liked the bill when it started. You like it a little bit less, or maybe a lot less, after it's gone through the amendment process. And both of you co-authored a piece that called the amendments coming out of committee unnecessarily broad and warned that it could be used to prevent Canadians from repairing some of their own devices. Can you explain, what changed in the bill, who was behind it, and what some of your concerns are?
Sure. So yeah, this amendment sort of came out of nowhere from my perspective. I don't know, Anthony, how you saw it, but so if we think about the Bill C-244 as providing an exemption to the TPM provisions, this amendment sort of provides a carve out from that exemption for products that have sound recording embedded in them. And so I think this is largely motivated, on its face, by the content industries wanting to, exercise their control. So, movies, music, video games, right? Like these industries that traditionally have sound recordings as like a sort of critical central element of their products and services. So this would remove that repair right, I guess, from those kinds of products. But the points that Anthony and I were making in our piece that you mentioned is that this is, essentially providing manufacturers with an incentive to sort of embed sound recordings and musicality now in all sorts of devices that they make. So I have a tea kettle that already sings me a song when the water is done boiling. We have toilets, we have all sorts of devices that will play a little jingle or music. And so now I think not only are we going to have homes filled with unnecessarily computerized devices that lock us out, they're also going to be singing at us, I think, while they do it.
So your concern sparked a response from MP Meow soon after we recorded our initial conversation. Clearly, the piece that the two of you wrote, received some attention and got the attention of government, and wanted to ensure that perspective was included in our episode. So how does the office or the government explain the exception that's been added to this bill, and what do you make of it, Anthony?
Yeah, so our interpretation of the bill originally was sort of concerned that this might be overly limiting in terms of the devices that the exception applies to. So it would only apply to devices, for example, with embedded sound recordings was one concern we raised. I guess the interpretation of the government anyway is quite the opposite, that it's only devices with works or embedded sound recordings that form, and in the language of the bill, part of the product. Would find some sort of protection from the bill in terms of repair. So this is quite a different perspective from what we have taken originally. But there's still some limiting factors with this bill. There's still some very confusing aspects, even adopting that interpretation.
Okay. Alissa, you have any thoughts on that? I have to say that sounds like a pretty puzzling interpretation, given that at a minimum, as we discussed earlier, the agriculture sector was one of the lead proponents of this legislation. And that interpretation would seem to suggest that their concerns aren't even being addressed in this bill at all. Alissa, how do you see what the government has to say and where it leaves this bill?
Yeah, so I mean, if it's true that this sort of exemption on diagnosis, maintenance, and repair only applies to sound recordings or products that have sound recordings or performances embedded in them, I mean, that is such a big diversion, I think, from where this bill started and what its intentions were. So my reaction to that is like, how does this possibly make any sense? Like, I really don't think that it makes sense. And so what I would say, though, is that what this amendment has done, I think, pretty clearly is added a lot of additional unnecessary confusion into this process. I spent some time reviewing the bill and the amendment and thinking about, you know, what the original TPM provisions in the Act say. And revisiting it in this way sort of highlights, I think, some additional concerns for me, in addition to this sort of curious focus on sound recordings. So if we look at the TPM provision, which is 41.1, there's sort of three subsections there. And that section says, no person shall circumvent a TPM. That's section A. And so this amendment that we're talking about to Bill C-244 is dealing with that subsection specifically. The two subsections that follow are slightly different. B deals with people who offer services to the public to circumvent TPMs, and C deals with those who sort of traffic in tools or services that would circumvent TPMs. And so my concern at this point is really that what this amendment is doing is potentially excluding those who, you know, create the circumvention tools from having coverage under this act, which would be a huge problem because, as we know, individual users are most likely not going to have the sort of technical skill to be able to circumvent TPMs. Now, I will note that the amendment has a section that says, for clarity, this amendment also applies to sort of people who are doing it on the user or consumer's behalf. But it's not clear to me that even with that clarification that would cover independent service technicians or who are sort of performing this work for commercial purposes, or for those who sort of whose business is to sort of manufacture or make these circumvention tools.
Assuming it gets through the House, and it sounds like at some point in time it will, if it's gone through committee and it got that kind of support. I guess the Senate lies ahead, and you know, as we look ahead, you know, you have any thoughts on the possibility or prospect that we'll get similar kind of hearings at the Senate, and perhaps a willingness for that sober second thought for the Senate to revisit at least some of those issues, to say, hold on a second, the intent here was not to narrowly carve out certain kinds of devices that in many respects may be some of the most important ones for everyday consumers, and find that in fact the status quo is in some ways almost embedded, where there's been an attempt after more than a decade to fix the issue, and suddenly we're right back where we started. Alissa or Anthony, you have any thoughts on sort of what comes next in that regard?
Well, you know, it's hard to kind of guess what our chances are for improvements from here, but I can say that over the past couple of years, I have been given the impression that senators are very keen to deal with the right to repair. And I mean, I guess without saying more than I'm allowed to say, you know, I've been contacted by folks who are very interested in pursuing legislation to enact the right to repair at all levels of government. And I have some faith that there is some interest among the senators to ensure that the way we pursue this issue in Canada is done right. And so one can only have an optimistic point of view if one wants to see the right thing happen. I think it's not a foregone conclusion that the bill will be adopted as is, or sorry, take force into law as is, but I guess in some ways we're kind of relying on that sober second thought and some really close discussion among senators.
Okay, Alissa, you have any closing thoughts on both this longstanding battle to get this onto the legislative agenda and what comes next?
Sure. Um, what I would say is that, I am hopeful. I have sort of an irrational hope, undying hope that this will go through without being carved up too much. As we've seen in other places like the US and other sort of jurisdictions, there is a tendency for these like well-intentioned bills to be sort of chopped up into bits at the last minute. So hopefully we can avoid repeating that mistake here in Canada. The other thing that I'll say here is that, we've been focusing on copyright law, of course, but this bill isn't a silver bullet to solve right to repair issues here. Even if we just limit it to sort of the legal impediments, we also need to look at making some modifications and changes to competition law, and also at the provincial level to consumer protection and contract sorts of laws. And I just mention here that a bill was just introduced in Quebec, I think 2 days ago, Bill 29, that at the provincial level would create a legal warranty of good working order, I think they call it, which is a new sort of legal warranty. It would also require replacement parts and proprietary tools and information to be made available. And it would limit or extinguish actually planned obsolescence. So it's great to see that there's activity happening both at the federal level and at the provincial level. And I hope that other provinces sort of follow Quebec's lead and start taking matters into their own hands.
Okay. Well, listen, both of you have been really at the forefront of putting this issue on the agenda. And as you say, it's more than just a copyright issue. There's a clearly a role for provinces and clearly a role for non-copyright related aspects here as well. And so thank you for both of your efforts in that regard. And thank you for joining me on the podcast.
Thank you so much.
Thanks for having us. Thanks, Michael.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbites@pobox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.